Charge.
Oh, me, excuse me, Dave, I wasn't trying to get you left.
Okay,
We're good to go.
ready to.
Okay. 2012025-821, 2012025-822, 2012025-823. Complainants are lessees and respondents are affiliated with a firm which represented the property owner from whom complainants decided to lease. Respondent 3, an affiliate broker, initially met with complainants to show complainants the subject property and fill out an offer to lease and lease application. Respondent 1 is the principal broker, and Respondent 2, a broker, met with complainants during the leasing process to sign the lease and perform the walkthrough prior to complainants taking occupancy. Complainants state that they contacted Respondent 3 concerning rental of several properties, and they thought that Respondent 3 would be representing them in the lease process. After looking at a property, complainants were told that complainants needed to fill out an offer to lease form and give a check for a deposit and another $50 check to Respondent 3 for a background credit check. Later that day, complainants state that they attempted to contact Respondent 3 to stop the process as they had found another possible house, and complainants state they could not reach Respondent 3 until the offer to lease had already been submitted. Complainants state that Respondent 3 informed complainants if they reneged on the offer, they would lose the deposit, and the owner had 72 hours to respond. A few days later, complainants state that they got a text stating that there was an accepted offer to rent. Soon after, complainants state they contacted Respondent 3 to find out what came next and were told everything from that point would be handled by the listing agent, and Respondent 3 would have the listing agent contact complainants regarding signing the lease. A few days later, complainants state that they had still not been contacted and found out from Respondent 3 that the listing agent was out of town. Complainants asked for a copy of the lease review, which was provided. On the following day, complainants contacted the owner broker, Respondent 1, about requests for changes in the lease and were told that Respondent 1, the listing agent, was out of town and had not planned on meeting with complainants until about 5 days later, but that Respondent 2 was available to meet with complainants in the interim. Complainants were further told that the requests for changes to lease were issues already covered under the Tennessee Landlord-Tenant Act, but Respondent 1 had no problems with adding the terms if desired. Respondent 1 further explained that the agents in the rental department always represent the homeowner, and Respondent 3 was simply a showing agent who was helping Respondent 1 in Respondent 1's absence. In a reply email to Respondent 1, complainants state that had they known that Respondent 3 represented the homeowner, not complainants, complainants would not have entered into an offer to lease. Respondent 1 then enlisted Respondent 2 to meet with complainants, and complainants again expressed concerns over the lease language. Respondent 2 stated that issues were covered by the Landlord-Tenant Act and assured complainants that the house would be cleaned and complainants would be given an agency disclosure form. And complainants were given an agency disclosure form. At the walkthrough, complainants state that Respondent 2 stated the house had been cleaned. However, complainants had issues with the cleanliness of the house, which complainants state necessitated an extensive further cleaning, and complainants expressed concern over what complainants believe may have been stored in the home. Complainants found items and bags of trash which complainants wanted removed and were told to leave them by the street, and items would be picked up as trash, which complainants did not feel should be their responsibility. Complainants said that they were lied to, manipulated, and cheated, and are concerned they may have future health problems from living in the house. Respondent 1 sent a letter as a response from all respondents, and Respondent 3 also sent additional information. According to respondents, the company has an inventory of available rental properties, and an agent is sent to show the property, but that agent does not represent the renter, as they represent the owners of the properties. Respondents state that when complainants called about the subject property, Respondent 3 was the rental agent on duty and showed the property. Respondents state that the practice of the office is not to present any offers to lease to an owner until a deposit has been paid by a potential tenant. Respondents state that the offer contains a statement alerting the potential tenant that it could take up to 72 hours for a lessor to respond, and once a deposit check is written and the offer made, the offer cannot be revoked by the potential tenant, but the deposit could be returned if the offer is rejected. With regard to the allegations that no one contacted complainants, respondents state that the firm rarely does walkthroughs and lease paperwork prior to the week before occupancy. Respondents state that respondents were in regular contact with complainants. Respondent 2 was with complainants for the walkthrough, and during that time, Respondent 2 called Respondent 1 concerning the items left by prior tenants, and Respondent 1 advised the items could be placed out for trash pickup. After the walkthrough, respondents state that all tenants, including complainants, sign a document accepting the house in its present condition, which they did, although they had the right not to sign if the house was not in acceptable condition. Respondents deny any wrongdoing, stating that they have been honest and accurate in all communications. The offer to lease document signed by complainants states the offer terminates if not countered, accepted, or rejected within 72 hours or a specified date on the document. The application signed by complainants states that upon approval of the application by the owner, the applicant agrees to sign a lease and pay the first rent payment, and the applicant understands that the deposit would not be returned if the applicant tenant refuses to sign the lease. The lease does not contain the language requested by complainants via email, but all documents were signed complainants, including the property condition report from the walkthrough. It does not appear that there was a violation of TREC statutes and/or rules by respondents, and therefore the recommendation is to dismiss.
Do I hear a motion?
So moved.
Got a motion from Mr. Flickcroft. Do I hear a second?
Second.
Second from DeChara. Any discussion? People are thinking.
I'd just like the record to reflect that even though I wasn't here at the beginning of this, I have read this complaint and I fully intend to vote.
You fully intend to vote.
And I left the room and re-entered, but I also had read it.
Okay. So noted. Any further discussion? Call for the vote? Or more discussion? People are thinking about it. We don't want to rush into it.
Call for the vote.
Call for the vote. All in favor? Aye. Opposed? Okay, Julie, keep going.
Okay. 9, 10, and 11, 2012-026-551. I'm sorry, wait. Okay, 2012-026-551, 2012-026-552, 2012-026-553. Complainants were the sellers of a home. Respondent 2, affiliate broker, was complainant's broker for the sale of complainant's home and also the facilitator for complainant's home purchase. Respondent 1 is Respondent 2's principal broker, and Respondent 3 is a broker at the same firm as Respondents 1 and 2. Complainant initially contacted Respondent 2 in response to a proposed sale of a home to be built. The contract for complainants to purchase the home was signed by, I'm sorry, it's water. The contract for complainants to purchase the home was signed on October 17th, and Respondent 2 served as facilitator, and the final counteroffer accepted and signed by all parties on October 25th. During the negotiation regarding complainant's purchase of the first home, complainant states that Respondent 2 said his partner or his partner's mother might be interested in the property and that they viewed the house for that purpose. Complainants state that at that time, complainants were in a one-time showing agreement with another agent, and that Respondent 2 knew that the agreement had an original term from August 31st to September 30th with a clause that stated that if the property was sold directly by the seller to the prospect within 60 days after the specified August through September period, then the seller agreed to compensate the broker. Complainants state that an offer on their property was conveyed to them on October 1st and rejected, and that multiple offers and counteroffers followed. An additional offer by the other agent's clients was made on October 31st and rejected by complainants. On November 1st, complainants signed an exclusive right to sell listing agreement with Respondent 2. Complainants state that this was with the understanding that the one-time showing agreement was excluded from the listing agreement. Complainants state that a copy of the listing agreement was not given to them at the time of signing, and that complainants understood that the listing agreement would not supersede the one-time showing agreement. On November 4th, complainants countered the October 31st offer on complainant's home and told the other agent that the house was now listed with Respondent 2. Complainants assured the other agent that the one-time showing agreement was exempt from the listing agreement. On November 9th, a contract for the sale of complainant's home from the original buyers was reached, and complainant notified Respondent 2. Complainant states that Respondent 2 told complainants that the listing agreement would override the one-time showing agreement. Complainants state that they did not wish for Respondent 2 to benefit, and they were never given a copy of the listing agreement. On November 12th, complainants learned that Respondent's firm asked for a copy of the purchase contract, and complainant attempted to terminate the listing agreement. There was a settlement offered so that there would be a 5% commission to be shared between the two, but complainants state that Respondent 2 is not entitled. Complainants state there were also issues with the purchase of the house to be built, and complained that in the counteroffer approved by complainant, there was a paragraph stating that the buyers will be listing their current property with Respondent 2 and company as soon as renovations to back patio are completed. Buyers have agreed to accept any offer at or above $1.7 million. Respondent submitted a timeline and copies of documentation. Respondent 2 states that Respondent 2 could have listed Respondent's home prior to November 1 date the house was listed if exclusions were to be part of the listing contract. Respondent 2 states the property was not listed until complainant notified Respondent 2 that complainant had rejected the last and best offer. Respondent 2 states that there was no personal interest from his partner or partner's mother, but he did think that one of the two might be interested. However, after reviewing photos and seeing the house once, neither was interested, and that was why there was no personal interest disclosure. Respondents submit that the contract to build signed by complainants had a provision that Respondent 2 was to list their current property, and this was signed on October 22nd. On October 25th, Respondent 2 states he met with complainants who told Respondent 2 that they were going to give the proposed buyers from the one-time showing until October 31st at noon. On October 27th, Respondent 2 inquired about the showing, and complainant stated again that this buyer had until October 31st. The parties again were in communication on October 29th, and on October 31st, a text from complainant states the complainants refused the offer again, and that was a worse than their final offer before. Respondent 2 states that arrangements were then made to execute a listing agreement. On November 1st, complainant signed an exclusive right to sell listing agreement, and Respondent 2 states that the complainants made copies. Respondent 2 listed complainant's property on the MLS on November 5th. Then on November 9th, Respondent 2 states that complainants called about the purchase of the home to be built, and in that conversation stated they accepted an offer on the other home. Respondent 2 states that Respondent 2 reminded complainants of a listing contract stating that all offers were to go through Respondent 2's company, at which point Respondent 2 states that complainants requested an emailed copy of the listing agreement. When complainants then began contacting the other firm regarding the commission, when respondents then began contacting the other firm regarding the commission on the sale of complainant's home, complainants instructed Respondent 2 via email to terminate the listing agreement and remove the property from the MLS, to which Respondent 2 responded that respondents were seeking legal advice. Complainant's property was sold, and a lawsuit was filed by Respondent's firm and Respondent 2 against complainants for the commission under the contract, and that lawsuit is now pending. With regard to the house which complainants were purchasing, additional information was obtained which indicated that complainants had the house appraised. The house was still under construction, and the appraiser found the property to appraise at an amount below the agreed upon sale price. Based on this appraisal, complainant's attorney wrote a letter to Respondent's firm notifying it of the appraisal and requesting a return of complainant's earnest money, to which complainants state that respondents have refused to return the earnest money. Complainants and respondents disagree as to whether the seller of the new construction home will agree to release the earnest money, but no earnest money disbursement form has been signed by the parties based on the information provided. Respondent 2 states that the appraisal was based on a hypothetical condition that the improvements would be completed according to the information furnished to the appraiser. At that point, Respondent 2 states that the parties engaged in discussion because complainants wanted Respondent's firm out of the transaction. According to Respondent 2, the parties attempted to work out a settlement regarding possibly dropping the lawsuit and the firm removing itself from the new construction sale if the firm's attorney's fees could be paid. Respondent 2 states that as of April 24th, Respondent's firm has given complainant's earnest money to its attorney to enter into court until a decision is made regarding who is entitled to the earnest money. There are a variety of allegations listed in this complaint, and it appears that many of the issues disputed between complainants and respondents, including the understanding regarding the listing agreement and its relationship to the agreement to show property, and this commission issue is one which is being determined by a court. With regard to the earnest money for the new construction property, there is likewise disagreement as to the situation. However, it appears that it was determined that the earnest money should be interpled on or about April 24, 2013, and the money was given to respondent's attorney at that time for the purpose. The recommendation is to close as to respondents 2 and 3, but as to respondent 1, send a letter of instruction regarding Rule 1262.09, subsection 3, which states that brokers are responsible for deposits and earnest money accepted by them or their affiliate brokers, and subsection 6 of which lists the number of conditions which allows a broker to properly disperse funds from an escrow account, and subsection 7 of which states that funds should be dispersed or interpled within 21 calendar days from the date of receipt of a written request.
Move to accept council's recommendation.
Second.
I have a motion by Commissioner Alexander and a second by Commissioner Northern. Any discussion? Let's vote on Julie's motion to recommendation. All in favor?
Aye.
Opposed? Thank you. Next.
Next, 2012-026-581. Complainant purchased a property which was listed by respondent, principal broker, in 2011. Complainant states the complainant decided to purchase the property based on the extra large size of the lot and an adjoining wooded lot. Complainant states that the advertising of the home, including the MLS, advertised the property as being sold with the vacant lot. Further, complainant states that the items on the HUD statement for complainant's purchase indicate that complainant purchased both the property and the adjoining vacant lot. Approximately 1 year after complainant purchased the property, complainant claims that respondent listed the adjoining wooded lot for sale. Complainant states that complainant submitted an offer which was never responded to by respondent or the owner of the lot. Soon after, complainant states that the adjoining wooded lot, which complainant states was a part of complainant's property, sold to another individual. Complainant states that neither respondent nor the title company which closed complainant's sale have corrected this issue. Respondent submitted a reply stating that the purchase and sale agreement submitted by complainant's agent on behalf of complainant did not include the purchase of the adjoining vacant lot, but instead only included the property address which contained the residential home and made no made no mention of purchasing the adjoining lot. Respondent states that the adjoining lot has a different parcel number, tax card, and separate deed from complainant's property, which respondent states that complainant and complainant's broker knew or should have known and should have specified in the purchase and sale agreement if both lots were intended to be purchased. When complainant purchased, respondent states that the MLS listing only included size and tax information on the lot with the home and did not include the size, tax, or deed information for the additional lot, but was only mentioned in the remarks box as having an extra adjoining lot. Respondent states that complainant is aware that complainant purchased only the lot with the house because the warranty deed references only that address and parcel number and not the separate number for the adjoining lot. Copies of the purchase and sale contract and warranty deed appear to confirm respondent's statements. Later, respondent states that respondent was engaged to sell the adjoining wooded lot as well. At that time, respondent states that respondent submitted a lot offer through complainant's broker, and the seller did not wish to respond to the low offer. I'm sorry, that was supposed to say a low offer through complainant's broker, and they did not wish to respond to the low offer. Respondent states that this offer shows that complainant knew that complainant had not previously purchased the adjoining wooded lot. Respondent states that another buyer submitted a higher offer closer to the list price and the lot was sold and transferred to that buyer. Based on the documentation submitted by the parties, a civil action was also instituted involving numerous parties, including complainant and respondent, regarding which complainant originally submitted information to TREC stating that the issue had been settled and complainant no longer wished to pursue the TREC complaint. Later, the complainant submitted a letter insisting that despite the settlement, complainant still asserted that respondent illegally sold complainant's property to another party. This letter was followed shortly by a statement from respondent redacting the comments and stating that all matters between the parties had been resolved. Respondent submitted additional information through an attorney stating that the properties are two separate properties with two separate deeds and legal descriptions, and the contract submitted by complainant's broker on behalf of complainant to purchase the property only specified the address of one of the lots that included the residential home and made no reference to the additional wooded lot, and the warranty deed and settlement statement from closing only referenced the lot with the residence and not the adjoining wooded lot. Based on the information submitted and obtained, although there may have been a misunderstanding on the part of complainant and/or complainant's broker as to what property complainant originally intended to purchase and ultimately purchased, it does not appear that there was any violation by respondent with regard to the sale of the property. However, it appears that a listing agreement with the owner of the property and respondent did not include a termination date, which respondent's attorney states was a one-time oversight, as respondent typically designates a 6-month expiration date. Though there does not appear to have been any harm created by this, respondent would benefit from a letter of warning regarding including termination dates in all contracts. The recommendation is a letter of warning regarding Tennessee Code Annotated 62-13-312B9's prohibition against utilizing any listing agreement, sales contract, or offer to purchase forms that fail to specify a definite termination date.
Motion to approve council's recommendation.
Second that motion.
Straight comment.
Okay.
In your comment, you said that the MLS in the remarks box said that it was advertised as having an extra adjoining lot. Is that exactly how it was stated?
There were a number of MLS listings. Do you want me to pull it out and read it?
No, but is that basically what it was saying?
Or did it just say it was available?
Let me pull
Doesn't
it.
say anything about availability in her statement. That's why I'm asking.
Yeah.
Let me pull it just to be sure, because it's been a while since I've looked at it, and I don't want to tell you wrong.
I know that, but I mean, as to the letter of warning, I think you should reference something about that.
While Ms. Crop is finding in this
It's already
file
adjudicated, so it doesn't
this
matter.
information, I just want to share with all of you attendees. Some of you have already been told this, but in addition to being the attorney for the Real Estate Commission, Ms. Crop is also the attorney for the Auctioneer Commission.
Here,
So she reads so fast.
the first one I pulled here says, well-maintained home on large lot, has an extra lot adjoining, is how it,
That's worded pretty poorly.
and has extra lot adjoining, that's the same one.
That's enough for me. I mean, I think your letter of warning should include some comment about statements that could be misleading.
Do you want something about the advertising rule? Let me see if I can pull.
I just think misleading statements
Yeah.
is fine.
Well, would the MLS be advertising? That would be advertising.
Yes.
Yeah.
Let me pull my advertising. See, because I just want to be clear on what y'all want me to put in there. That's not there's, in the advertising rule, it says, under just general principles, no licensee shall advertise in a false, misleading, or deceptive manner. I don't know if it necessarily, falls to the level of discipline here, but we could put that in the letter of warning, just. Would you like me to add that too?
Yes.
Is that a motion?
That is a friendly amendment to the motion.
Friendly, okay, I've got a motion by Commissioner DeChara to take your recommendation, a second by Commissioner Stevens. We've got Commissioner Northern with a friendly amendment. Do I hear a second? Or do we have to do that?
No, just.
Know that.
Part
It's part of the motion. You got it, Julie?
Yeah, I'm just writing down the rule number, so I'll have it for when I go to write this.
Okay. The motion is to accept Julie's recommendation. All in favor? Aye. Opposed? Thank you. Next, after she gets that written down.
Okay. The next one is 20130000251. This is a complaint opened at the direction of the commission based on information which was included as part of another complaint filed against another licensee. The information in the complaint filed against the other licensee suggested that respondent, a principal broker, paid a commission to an affiliate who was not affiliated with respondent's firm. This complaint was opened against respondent to obtain additional information regarding the potential issue regarding respondent's payment of the commission to that affiliate. Respondent submitted a response vigorously denying any wrongdoing. Respondent states that in 2011, the partners of respondent's firm began exploring a franchise situation with a licensee who wanted to open a firm and borrow from respondent's branding and support while being the principal broker of her own firm. Respondent states that the partners of respondent's firm agreed to work with that licensee while she opened her firm if she met a number of conditions, which included but were not limited to that licensee being the principal broker and that licensee working with the firm's accounting department to develop proper accounts and follow certain policies and procedures. Respondent states that soon after it was discovered that the licensee had already opened her own firm and hired another licensee as principal broker. That principal broker was the licensee from whose complaint file this information came. Because the licensee agreed to meet certain conditions in order to have the franchising agreement with respondent's firm, and because the conditions were not met, the relationship with that firm was severed. Respondent states that respondent learned most of this after the fact, and at the time only understood that there might be a possible franchise opening. Around that time, the subject affiliate broker, who was at that time affiliated with the firm which was working toward a franchising agreement but has been affiliated with respondent's firm since shortly after the subject closing where the commission was dispersed. The other firm ultimately closed. Arrived at respondent's office for a closing, which respondent states was not unusual because respondent's firm office allows all 6 affiliated firms to use its office space. When this is done, respondent states that respondent transmits the check, which in this case was made out by the title company to respondent's firm and not the firm at which the affiliate was at that time affiliated, by remote deposit machine, which goes into accounting and notifies the affiliate's principal broker. Respondent states that respondent does not handle the money and the centralized accounting department does it all and notifies the principal broker that the deposit was made. Respondent further states that the affiliate turned in all post-closing paperwork to his principal broker. Respondent states that the affiliate gets 100% of the commission, so none goes to the principal broker of the firm. Respondent denies any wrongdoing and states that respondent's firm prides itself on its compliance record. Based on the information supplied by respondent, it does not appear that respondent violated track statutes and/or rules, and the recommendation is to dismiss.
Do I hear a motion?
I make a motion, we take council's recommendation and dismiss.
I have a motion. Do I hear? I have a second from Commissioner Flitcroft. Commissioner Stevens made the motion to accept Julie's recommendation. All in favor? Aye. Opposed?
I have a question.
I didn't ask for discussion. I'm sorry.
Now, I'm okay with the vote,
Okay,
but I have a question with regards to policy.
okay.
Staff opened the complaint against an individual, and we end up dismissing the complaint. And according to this, it was open to obtain additional information. Couldn't we get additional information without opening a complaint?
Well, there was limited information in the other file, and based on what we had at that time, the commission said we think a complaint should be open. We didn't have all of this additional information at that time. There was no indication regarding all of the details that this person.
Have we requested it rather than opening a complaint?
We just followed the direction of the
So this
commission.
commission asked that it be done?
We didn't have all of these facts at that time, and it was a complaint that was open for kind of very different reasons. This was a side issue
So
to
will
that.
this individual's record show a complaint?
It'll, it's dismissed, so.
Shows a dismissed complaint, but all complaints, show, because we don't expunge records or they don't fall off after a period of time. It's not listed as disciplinary action because none was taken.
But there's now a complaint of record against this individual, even though it was dismissed.
Correct, because it's open on RBS, so if someone were to call and ask, and that's true of any complaint, if someone calls and asks, how many complaints, calls and asks Connell, say, how many complaints does someone have, then if whatever shows up there, he says they have X number of complaints, but then he'll say, 5 were dismissed, or, he'll specify what action was taken.
I'd just like for us to be a little bit more cognizant of the impact of doing that without taking measures that doesn't rise to the level of a complaint.
Right, this was
If we have the ability to get the additional information without opening the
We
complaint.
didn't know there was additional information.
Yeah, we didn't know there was additional information, but this was a complaint that the commission itself asked us to open.
I understand,
Yeah.
I'm speaking to
Right.
this body, including myself. We should take that into consideration.
Let's go back a little bit further, Isaac. Was the original complaint, who opened that complaint?
The original complaint was filed by the principal broker of the firm that wanted to set up the franchise agreement and was unsuccessful in doing so. And that was the individual who filed the complaint. And so it was her,
As
the
part of her
original person's,
response.
right, and that person's complaint was filed against the respondent in this complaint. And
I'm
So
not
we
sure.
aided that individual in throwing dirt on someone who didn't necessarily need it.
Well, I'm not sure that there's not a violation here. It's illegal to pay another agent unless it's in your company.
Well,
Is it?
I'm not saying that that's.
But
that
we
was
voted
legal
to
action.
accept council's recommendation, but I'm not sure that there's not an infraction here. Because a commission was passed, paid to someone other than in that company. So you've just violated a transaction here.
I got no problem with whether or not. the
I understand, but
commission
if
was- I'm
if
thinking
you're
about
picking
practice
councils
of
there,
opening a
you
complaint
vote, we've
without-
all sat here and voted to pass over a violation. Cause a commission, if I interpret the complaint.
Discussion.
Huh?
Write it down.
I
in
know,
big letters.
I got it right here, discussion.
Am I wrong?
Well, I was
Okay,
kind
where-
Well, you can cite an affiliate for accepting a commission or any other valuable consideration by an affiliate broker for the performance of any act specified in this chapter from any person except the licensed real estate broker, but there's not something that directly speaks to the broker paying it that I can.
Oh, so if I'm a broker and I wanna pay Janet's agents out there, I'm legal, but it's illegal for them to take it? Is
I
that
guess
what you're saying?
We could find something probably diligently exercising, but as far as under 312, that it's listed in the terms of the affiliate accepting it,
Well,
not.
ain't that a new worm?
That's not the reason for the recommendation. The reason was for the facts surrounding the confusion of the franchise.
Discussion, and Michelle skipped discussion.
And I skipped discussion. Should I back up?
Now you back
Based
up.
on this discussion, I rescind my motion.
Okay, based on the
And I'll-
discussion, let's back up to the discussion part and before our motion.
And I was woeing you, but I didn't. get
I
my woe back.
apologize.
Well, I don't know. You-
The reasoning
I
for
don't
it,
know what you're telling me, that whether now there is a violation. I never heard of the fact that a broker could pay anybody that wanted to. But if that's gonna be, so what am I gonna do if I pay an unlicensed individual commission?
well, there is a statute prohibiting.
That's kind of like the 50-mile rule where the agents have to live within 50 miles, but the brokers don't have to. This is the same kind of thing. They can't accept it, but we can give it to them.
I think if we had more egregious facts, we could probably find something in terms of not exercising reasonable diligence. But in this case, it appears that there was a central accounting system, and this person, it was believed that this person was part of a franchise. It was routinely submitted to the central accounting system, and the check was dispersed through there. This individual did not cut this check to the person.
So that means the broker's not responsible if it's done
Because he has
through
a central accounting system?
Well, what if the title company closed it and they never touched it?
Yeah,
Yeah,
I mean, there's all
that happens
kinds of things.
Mr. Flitcroft's office closed it and he just paid the commission to the wrong agent. Is that what you're saying?
Paid it to the agent, not the broker.
He's gotta pay the money to the broker and then the broker disperses the money.
That was my recommendation based on the facts. If you all disagree, we can keep discussing it.
Well,
That's,
it's just really confusing.
It's a
that the
confusing
broker
situation.
Can do that, but yet an agent can't accept it. The broker shouldn't be allowed to do it.
well,
I mean, that may be something we need to address in our rules-making hearing. If-
Well, maybe it's
if
something we need to address to them.
Housekeeping rules.
this is a statute,
Leave it like it
so.
on, I'm a broker, so I can just, I'm not liable for the pay it to.
What's the statute say?
Well, it's under, what I read about accepting is under 312, where most of the violations, and then we have 302, which makes it unlawful to employ or compensate someone who's not a licensed broker or affiliate broker, but it doesn't go that far. So, I mean, some of those could probably be cleaned up to more clearly specified. I mean, I can look through these rules and find some sort of,
Let me see how I'm gonna do this.
Yeah, I'm
Madam
confused.
Chairman,
Yes, sir.
I move that we table this motion for further research. Table this
This complaint.
complaint, or the complaint or the motion is.
The motion is to
I'm gonna
dismiss.
table that motion or the complaint
Well, I have
for
a,
further research and we report next month.
okay, I have a motion that we table the motion until, for further discussion, or rescind our motion?
He rescinded it.
I mean, let's do this
Let's do it
according
right.
to Robert's Rules of Order. And
Well, that's what I'm trying to do.
And I am not totally familiar with what you do when you have taken an action, you have voted with a motion and a second, and you vote, and then how do you undo?
Well, she didn't
What
ask
you
for
did.
discussion.
But
so-
I
I
didn't
know,
do the
but you
motion
still, that
correctly.
doesn't matter if she didn't ask for discussion. That doesn't matter. I mean, but still, yeah, we took action.
Well, it kinda
Now, how do you negate the action that we
does. Make
took?
a motion to rescind.
Rescind our action.
Okay, well, that's what I did. I made a motion to
Okay,
rescind my
but I don't have a
action.
second.
And I'll second that.
I have a motion by Commissioner Stevenson to rescind our motion. I have a second by Commissioner DeChara. Is there any discussion?
well, wait a minute, hold on.
All in favor to this motion, say aye. Aye. All opposed? Motion passes. Now,
we
do
need
I have
Commissioner
another motion?
Alexander's motion.
Pardon? Table.
Because
I move to
it's
table
unlawful to accept it.
this complaint,
To table or defer?
well, either one. Defer. We'll defer the complaint for 30 days or until the next commission meeting for further research from legal.
Okay, I have
I
a
think I
motion.
found something.
Oh, okay. What'd you find?
See if this works for you. Okay, under 312, B17, it is prohibited, well, it says that they can, the commission can take legal action for someone who's found guilty of, 17 states, paying or accepting, giving or charging any undisclosed commission, rebate, compensation, or profit or expenditures for a principal, or in violation of this chapter. The way that you could state that it is in violation of this chapter is because B11 prohibits an affiliate from accepting it.
Okay. So the broker was in violation of that.
So do we want to table it, or do we want to go ahead and talk about it?
Let's table it, let's take this up next month.
I know, I'm just saying, I want to try it.
I'm just saying that's a roundabout way of finding, but it says or in violation of this chapter. B11 makes it in violation for the affiliate to accept it.
Well, that's definitely something to put in our rules making, that we need to clean that
No, it
up.
clears it up. It cleans it up now, doesn't it?
Good luck on that one, Robbie.
Thank you.
Well, it still needs to be cleaned up in that other
What,
section.
now, let's leave it till next month and let's
Okay,
research it.
I have a motion by Commissioner Alexander to table. Do I hear second?
Second.
I have a second by Commissioner DeChara. Any discussion?
You're really deferring.
What's that?
Deferring,
Yes.
I'm deferring.
It's
Deferring it
Tennessee Code.
till next month. Okay, all in favor of the motion to defer it until next month, say aye. Aye. Oppose? Okay, it's deferred.
And Robin, told us.
Mr. Norm, you did a good job. He's right, dude.
Yeah? We were just moving through too quick.
Y'all can do whatever you want to these timeshare folks. I really don't care. And that's on where.
Okay, we're ready.
14?
Yes.
Okay. 2013-001151. Complainants were existing timeshare owners who traded in their existing timeshare in 2008 for a new contract with respondent, timeshare registration. In 2012, complainants attempted to contact respondent requesting that respondent buy back complainant's timeshare, and complainants were told that respondent did not purchase timeshares back from owners and did not offer refinancing at a reduced interest rate. Complainants state that at the time of their purchase, complainants were told that respondent had a first right to purchase and thought that respondent would buy back the timeshare. Respondent submitted a response stating that complainants have been longtime owners with multiple purchases over the years. In 2008, respondent states that complainants traded one of their existing contracts to purchase a new contract. Respondent attached a copy of the contract signed by complainants in 2008, which stated that respondent has a right of first refusal if the owner wishes to sell, but the owner acknowledges that respondent has no obligation to exercise the right to buy an ownership. Additionally, respondent provided signed statement of understanding signed by complainants, which addresses a number of issues, including but not limited to respondent's right of first refusal and the fact that respondent has no buyback program and does not provide resale assistance. Respondent states that there is no information substantiating the allegations of the complaint. However, due to the long ownership relationship with complainants, respondent agreed to cancel complainants' existing contracts with no further obligations. Based on the documentation within the file, there does not appear to be a violation by respondent.
Got a motion to dismiss by Commissioner Northern. Do I hear a second?
Second.
Second by Commissioner DeCharo. Discussion?
Call for the question.
No discussion? Do we?
Call for the question.
Question is to accept her recommendation to dismiss. All in favor?
Aye.
Opposed? Motion passes. 15.
15 and 16, 2013-001161, 2013-001162. Complainant states the complainant met with Respondent 2, timeshare salesperson. Respondent 1 is a timeshare registration. Complainant states that Respondent 2 offered complainant an upgrade to complainant's credit card that would earn complainant more points per dollar spent, which would offset maintenance fees if complainant bought additional points from respondents. Complainant states that Respondent had just purchased more points in another state a few months before and got an additional credit card at that time and did not think complainant could get more. Complainant states that complainant told Respondent 2 that if complainant could get the credit card upgrade and offset the maintenance fees, then complainant would do it. Complainant states that complainant made the purchase and later received notice from the credit card company that the credit card upgrade was denied. Respondent submitted a response stating that complainant has been an owner for several years with multiple purchases, including the most recent purchase discussed in the complaint. Respondent stated that an individual also has the option to apply for a credit card at the time of the sale or by visiting a website which allows them to earn more points, and the credit card is issued by a credit card company in another state which is responsible for determining the terms and conditions. Respondents deny that complainant's decision to upgrade was because of the credit card, but to upgrade to a platinum level membership, and respondents state that complainant was never told that a purchase was required to obtain a credit card. Respondents state that they believe complainant was confused with regard to the credit card issue because complainant was approved for a bill me later option for the down payment, and respondents state the complainant was told she was declined for the credit card upgrade at the site and continued with the purchase. Complainant denies that complainant was told this. Further, respondents deny the allegations of the complaint but state that since complainant has been his longtime customer, respondents have agreed to cancel the subject contract purchase and give complainant a refund. The documentation within the file does not appear to evidence a violation by the respondents, and therefore the recommendation is to dismiss.
Do I hear a motion?
Motion to accept council's recommendation.
Motion by Commissioner DeChara. Do I hear a second?
Second the motion.
Second by Commissioner Stevenson. Discussion. All in favor of the motion to dismiss, say aye. Aye. Opposed? Okay, 17 and 18, 19.
17, 18, and 19, 2013-001-231, 2013-001-232, 2013-001-233. Complainants attended a timeshare owner's update, which complainant state turned out to be a timeshare sales presentation given by respondents in April 2011. Respondent 1 is a timeshare registration. Respondent 2 is a timeshare salesperson, and Respondent 3 is a timeshare salesperson. Complainants state that they were at the sales presentation for hours and pressured to purchase that day, even though complainants stated they attempted to leave. Complainants state there's a difference in the transfer equity amount in some of the documents of $155. The copy of the HUD statement received did not contain the seller's side, and some of the information was cut off the good faith estimate. Complainants also state that they were charged and given a title insurance policy even though they didn't ask for or agree to it. Complainants state they were told the timeshare would increase in value, which was not true, and complainants state they were told that complainants could rent out their timeshare and make money. Complainants state they were not fully advised to the cost of maintenance fees and did not have time to review the documents fully before signing. Respondents submitted a response to an attorney denying complainants' allegations. Respondents state the sales presentation was voluntary, which complainants knew as previous purchasers. Secondly, respondent states that respondents received all required purchase documents at the time of sale, and the numerical discrepancy of $155 is due to the cost of the quitclaim deed, which is deducted against the amount shown on the deed, which was disclosed to the complainants in a proposal signed by the complainants. Third, respondents state that the title policy is required as part of closing and is charged as part of the closing cost. Fourth, respondents deny misrepresentations with regard to the investment potential of rental income and state that respondents signed an acknowledgement form which discloses in relevant part that complainants understood that there were no representations regarding investment or resale potential, and the developer has no form of resale or rental program. Finally, respondents deny that there were misrepresentations or concealments regarding maintenance fees or rescission period, as the contract signed by complainants states that the maintenance fees and includes the contract cancellation provision in all capital letters. The documentation contained within the file does not appear to evidence a violation by respondents, and therefore the recommendation is to dismiss.
Motion to approve council's recommendation.
I've got a motion, Commissioner DeChara. Do I hear a second?
Second.
Second by Commissioner Northern. Any discussion? All in favor of the motion to dismiss, say aye. Aye. Opposed? Okay, let's go to, motion passes. Let's go to 20, 21, and 22.
2013-004-331, 2013-004-332, 2013-004-371. Complainants state they were misled by Respondent 2, timeshare salesperson. Respondent 1 is a timeshare registration. Respondent 3 is a principal broker in the purchase of a timeshare. Complainants state they were told they were buying a vacation club, ownership club, when in fact complainants purchased a timeshare interval. Complainants wrote to Respondent 1 requesting a cancellation, but were told it was postmarked one day late. But complainants state there were 2 intervening holidays, and although Tennessee law makes no exception for this, other states do. Complainants also raise a number of issues regarding the placement and wording of the rescission statement, and complainants were not shown the public offering statement during the contract signing. It was only sent with them in the materials they took home. Respondents submitted a response stating that complainants purchased a vacation ownership interest with a floating use right and assigned complainants a number of points as part of a points-based system instead of a fixed-week program at a specific resort, as is used in a traditional timeshare. Respondent states that when Respondent 2 confirmed that when Respondent 2 told complainants it was not a traditional type timeshare, it was meant to refer to part of presentation where traditional fixed timeshares were compared with Respondent's flexible points-based system. Respondent states that respondents received and signed a number of documents explaining the product they were purchasing and given a rescission period, and complainants signed a public offering statement receipt acknowledging receipt of the public offering statement. Respondent 3 states that the language in the public offering statement is drafted to comply with the laws of each state, that complainants reviewed a copy of the public offering statement, and that no one associated with respondents is trying to hide anything. Respondents state the complainant's cancellation request was postmarked outside the rescission period, which was the reason the request was denied. While respondents deny the complainant's allegations as a gesture of goodwill, respondents agreed to cancel complainant's contract with a refund. The documentation contained within the file does not appear to evidence a violation by respondents, and therefore the recommendation is to dismiss.
Got a motion by Commissioner Flitcroft, a second by Commissioner DeCharo. Any discussion? All in favor of the motion to dismiss, say aye.
Aye.
Opposed? Motion carries. Now, what do we got back here?
We have a supplement to my legal report. There's a few other matters that Robin is going to present. There was one of which that I had a conflict on, and so there are just 3 other short ones that she is going to handle.
Okay, Robin.
No number, except for it's number 1 on my report, and it's 2011-024-481. This was originally presented in December of 2011, And a partner one is 2011-029611, which was first presented in March. I will start with the original one. Complainant filed by out-of-state purchaser who contacted respondent, a licensed agent who operates an unlicensed real estate investment company, about the purchase of a home owned by a third-party seller. The complainant alleges the information received by the respondent was misleading as to the condition of the property, no disclosures were given, failure to disclose agency status, and various issues of deception and fraud. The respondent held himself out to be the true owner of the property. The respondent states he was investing in the property for the third-party seller and doing a simultaneous closing on both deals of the purchase and sale of such a property. He bought the property for $12,500 and then sold it to the complainant for $20,000. In his response, respondent states he's an investor, not a real estate agent, and that he owned the property by way of a contingent contract with the seller. Therefore, he is not under the jurisdiction of the Brokers Act. On September 23, 2011, respondent's broker sent a letter and form releasing respondent from the brokerage. Respondent has not completed necessary administrative measures beyond that. Then, recommendation for this part of the complaint was a consent order with a proposed civil penalty of $1,000 each for the above violations totaling $5,000 plus mandatory 4 hours of continuing education and ethics, attendance of a regularly scheduled 2-day meeting of the Commission, all within 6 months, for violation of an unlicensed firm conducting business as a broker under 6212-102 definitions and 6213-301. License requirement as well as 6213-312-1, misrepresentation. 3, continued flagrant course of misrepresentation. Additionally, there was a violation of TREC Rule 1260-2-021, administrative measures, and 1260-2-11, failure to disclose true position. In the March legal report, the same respondent, there is a note that respondent attempted to place a license in retirement status and was entered inactive due to education requirement on 1/1/2012, and as of 3/2/2012, license had not been renewed. This was an anonymous complaint against respondent, affiliate broker, stated respondent through operation respondent's business was holding himself out to be a licensed realtor when in fact complainant states respondent is not a licensed real estate agent. Additionally, complaint states that respondent is utilizing the designation of certified distressed property expert on social network profiles. Respondent states respondent has been a licensed agent for 12 years, but respondent has not acted in the capacity of a realtor in approximately 4 years and is not acting as a realtor through operating respondent's investment business. However, respondent states that respondent decided to keep the license active anyway. Approximately 1 month after the respondent's response was submitted, respondent's license was placed into inactive status. The firm that respondent is operating is an unlicensed firm and appears respondent is flipping houses and claiming to owe them or classifying them as investment properties. The recommendation at that time was a consent order for operating an unlicensed firm in violation of 6213, 312, 14, and 20 with a civil penalty of $1,000, in addition to attendance at a 2-day meeting of the Commission within 180 days of the respondent's execution of the agreed order. Now we're to the present. The respondent did not sign either of these consent orders and the matter proceeded to litigation. An investigation showed that despite the license expiration in February 2012, it would appear that respondent's business may now be operating without any license for either the respondent or the business. However, both consent orders were for violation of the Brokers Act pertaining to licenses, and litigation cannot proceed with the facts as presented. Therefore, my recommendation is to close these present files and open a new matter based on unlicensed activity that is supported as presented in the investigation.
So you're saying because they weren't licensed, we can't?
No, he was licensed at the whole time these two things were going on, and the allegations were for violations of the Brokers Act as a licensee. And therefore, I cannot bring litigation based on those facts and those violations because he's not licensed anymore. There is nothing to get.
Okay, so in the interim, his position changed.
His position changed. That doesn't mean there aren't some bad activities going on. It's just, I'm just saying that from a litigation standpoint, I believe the better action would then be pursue him, open a new complaint, and pursue him for unlicensed activity as evidenced by the investigation we had done.
So does that mean we do away with the imposed penalties?
But that means, yeah, well, I can't enforce those imposed penalties. Those penalties were based on violations of the Brokers Act of a licensee. And he is no longer a licensee.
I make a motion we accept council's recommendation.
I have a motion by Commissioner DeChar to accept council's recommendation. Do I hear a second?
Don't we need to state what that recommendation was?
Well, it's close both files and open new matter based on.
Close both files and open a new matter based on unlicensed activity as supported by the investigation. Okay. Do I hear a second?
Second.
Second by Commissioner Northern. Any discussion?
Everyone down there asleep?
Yeah, they're all asleep down there.
They're all asleep. What are we going to do?
And that is an excellent question.
What are we going to do?
Well, in this particular case, I think we've got a history of a person acting. Whether or not this person ever comes to a hearing is not really relevant in the grand scheme of things. You're right in that as an unlicensed person, we do have very limited power. However, if he's found to be unlicensed, there are civil penalties that can be assessed, and we have hope that a collection agency can then enforce the judgment, whatever that judgment might be. But that is about the limits of what we can do.
But if we wipe out all these recommendations, will they still be in his file that all this is?
That's something you'll have to address with Eve.
Because,
But right now, as presented to you, and as recommended, and as a part of the consent orders, the violations were for activities under the Brokers Act of a licensee.
When we do this,
And he is no longer a licensee.
Do you have evidence that this individual is still operating?
Yes, I do.
Well, first off, we need to notify the district attorney in the county in which he's operating, knowing we're probably not going to get anything done anyway.
You certainly can do that, and there's nothing wrong with doing that. But, again, my recommendation is to address this again with this commission as unlicensed activity. You don't have to do that. You could refer the entire thing to a district attorney. That's up to you. But still, a new complaint would have to be opened, I think, for those violations as unlicensed activity. Because that's based on the investigation subsequent to, and in preparation for litigation. That was what was revealed.
I still don't totally understand why you want us to close both files, even though he did it while he was under the Brokers Act?
Well, I can't punish him. You can't punish him for violation of the Brokers Act if he's not. You can punish him. You can do the same thing, do a civil penalty, but I can't. There's nothing you can take away.
I realize there's nothing we could take away, but at least we've done it.
Yeah, I understand that, but it would be to me, a futile.
Yeah,
But it's in this file.
But it's in his file, and at least it's documented.
So you would prefer to have a trial?
Well, we're not gonna, well, we'd have to, wouldn't we?
Yes, you
If
have to
that's
have a
where you're
trial.
going.
That's where I am. You would prefer, and if you prefer to have a trial based on the facts, then that's fine. It's just that it's a little harder to go forward at this point, because he's not a licensee.
That all
Oh,
we can do
gee,
at this point.
we are
is
really
unlicensed.
between
You
a rock
are.
and a hard place. Okay, well, we've got a motion to accept the new
If,
recommendation.
and this is a question that maybe I can address with Ms. Maxwell. If an unlicensed person is cited for unlicensed activity, is that something that is kept then if that person attempts to become a licensee?
That would, since the person has a file in RBS, that information would be reflected in that file, and we could put whatever notes are appropriate on his, on the person's file, so that it would be seen by us internally
And
if the person reapplies.
you should understand that your licensing section of the law is not just discipline for taking away a license, but it also provides that a commission can refuse to grant a license if there's been a finding under the violation. So if there was a finding on unlicensed activity, I think it's conceivable that if the license were then presented, it's 312. It's the licensing, it's the disciplinary action of it. And violating any order, violating a statute, the commission can refuse to grant a license or can suspend or revoke a license for violations under that section of 312. Section of 312 that also has a provision under 20 is for violating any other statute or section or rule, and one of that section or rule is unlicensed activity.
Everybody's thinking, more discussion?
Oh, we're waiting on,
The
Okay,
Council,
The greater benefit to the public would be to follow.
It's to string them up, but we can't do that.
give them a fair trial and hang them in the morning.
Yeah. This is the difficulty you have all around, is when there is egregious behavior going on, exactly what power we have in this division of the state. But I wanted to hear their discussion down there, because apparently they've got an issue.
I have a question for you, ma'am. If we take your recommendations, if there was a amendment to this motion, that this former licensee could not reapply, be reinstated until he answered these charges, can we do that?
In the terms of the formal hearing, in a formal hearing, is that what you're asking?
Yeah, what I'm saying is,
I-
this commission has voted to do this. Now you're asking us to rescind it because he is now not a licensee.
I'm not asking to be-
He or she.
Yeah. I'm not asking to rescind it.
My question is that if the motion had also stated that we drop these cases, but if he tries to re-enter the market, then he's got to answer to this complaint.
Well, it could. Let me explain that the biggest behavior in this, though, is that there is unlicensed activity going on, period. There was an unlicensed firm from the beginning, okay? And that was never brought as a complaint here. So I think the egregious behavior is the behavior in the unlicensed activity. So I don't know that he would ever come back.
I understand that.
I think he might continue to practice.
I'm all for going after him as an unlicensee, but I want to be able, if we can do it, that you block him from re-entering the market.
At this point, correct me if I'm wrong, Eve, he'll have to retest and reapply.
Right.
When he does his application, he has to disclose whether he has ever had a complaint filed or disciplinary action taken by any commission. It's a yes or no question. At this point, even if he answered no, I think the staff is familiar enough with this person that would know that there had been these 2 complaints out there. That would be reason enough for at least to bring this person in before this commission under the terms of your statute, which states that you know, licenses shall be granted only to persons who bear a good reputation for honesty, trustworthiness, integrity, and then we have these 2 files here that could
But
be
it also
considered.
says, if you look in 6213-312, it also says the commission has the power to deny a license based for any violations under that section as well.
If it's a violation of 312.
That's right, and this could be a violation of 312 under section 20, which is a violation of any other of the statutes or any of the orders.
14.
14, is it 14? Okay, 14.
If I could, Madam Chairman.
sure.
This tape runs out in 4 minutes, so we need to wrap it up. Hurriedly. We got a motion on the floor, I think.
Okay.
Yeah, we do.
Or switch the tape. I mean,
You got
'cause
another switch? Okay.
I have another one that's short.
okay, well,
We
he's,
can always switch it.
go ahead and switch the tape.
We can vote. You need to vote. on
Okay.